No, we're on mute.
I'm muted.
We can hear you.
Good morning, everyone.
Good morning.
And everyone, we're getting more chairs, so they're coming.
Jennifer?
Morning, Madam Vice Chair. Morning, everyone.
Good morning, Cassandra. Can you hear us?
I can hear you.
Good. Jennifer, can you hear us?
Yes, I can hear you. Can you hear me?
Great. Glad to see you. I hope you're hanging in there.
Yeah, it's good to see you all. A little soft for me. Can we, is anyone in here who can help us? Oh, want to say? Here, is this better? Yeah. Can you hear me? A little? Can you hear me better now? Oh, I hear you. It's Laura that I want to make sure I hear. Thank you though.
Oh. Madam Vice Chair, people are gonna have to keep their voices up because you're low. You're
Okay.
sounding low, not clear.
I will do my best. I'll speak.
Thank
slow
you.
And enunciate.
And more chairs are on the way, anyone who didn't hear.
Can you hear me in Springfield? Hi, this is Mike, the court reporter. We're doing this remote today, so I'm gonna need your help a little bit. When motions are being made, will you please state your name, as in, this is Member Turbin, so moved? And then when it's seconded, could you please say your name again? This is Member Craig, seconded. It will really help me when I'm making the transfer.
We'll do that, sir. Thank you.
Great idea.
Okay.
Bernadette, are we ready?
I think we're ready up here.
Tanya, can you hear us?
I can. It's a little soft, but I can hear.
All right, I will move closer to the microphone. Closer. All right. I will call the meeting of the State Board of Elections for Friday, August 23rd, 10:05. If you'll rise for, stand.
Somebody's watching. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Amy, roll call please.
Ms. Bellercroft,
Present?
Ms. Craig,
Present.
Ms. Genovese,
Here.
Ms. McCrory. And you have her
Oh,
proxy,
yeah.
correct?
Here.
Mr. Turvin,
Here.
Mr. Vrett,
Here.
Chair Donahue,
Present.
Chair Watson.
Here.
All right. Can I have a motion for the approval of the minutes of the June 18th and July 9th meetings? Member Gray, so moved.
Member Turbin, second.
Roll call, Amy?
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turvin,
Yes.
Mr. Vrett,
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
Yes.
Motion passes.
Now we will recess. If I could have a motion for the board to recess and sit as the State Board of Election, or recess with the State Board of Elections and reconvene as the State Board of Electoral Board.
Member Brett, motion.
Member Gray, second. Amy, roll call.
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turvin,
Yes.
Mr. Vrett,
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
Yes.
Motion passes.
I think one roll call. To the electoral board.
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turvin,
Yes.
Mr. Vrett,
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
Yes.
Let me see her. So they're elected. That's.
Now we need to approve the minutes of the electoral board of June 18th and July 9th. Member Craig, so moved.
Member Brett, second.
Amy?
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turvin,
Yes.
Mr. Vrett,
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
Yes.
Motion passes.
Barney? As a general,
Yes.
like to discuss the upcoming.
Laura, I'm having a very hard time hearing you, Madam Vice Chair.
Is that?
All right, Marty, would you like to give your report?
Yes, I will. So today, before I begin calling the cases, of the electoral board, I wanted to give a little bit of background about what's happening today. So today, the board will be hearing objections to the nomination papers of candidates seeking to appear on the ballot, for the general election on November 5th. For each case called, I will read a brief summary of the objection, a recommendation of the hearing officer, and my recommendation for the disposition of the matter. Parties will then have time for argument, and except in case 2024 SOEB GE 508, who have been given extra time for arguments. Objectors will have no more than 5 minutes to make oral arguments to the board, followed by candidates who will have no more than 5 minutes. That time has been increased to 10 minutes in the 508 matter because it's a lengthy and complex matter. These boards may grant you more time for argument if they wish, but under Rule 11, the board has the ultimate authority to decide what oral argument may proceed. The board has a number of cases to hear today, and the parties have already been given an opportunity to present evidence and arguments to their hearing officer. The board has been given copies of the objections, the dispositive motions, and for vacancy and nomination cases, they've been given the simultaneous briefs that were ordered by the hearing officer, and they've received the hearing officer recommendations to consider, as well as the recommendation of the general counsel. So there's no need to reiterate every argument your side has advanced. Please also remember there is no new evidence to be presented here today. This is an opportunity to make legal arguments and explain your position to the board. Once the board has voted on your case, you can pick up a copy of your board order from legal counsel to Sean Sarku in Chicago, who's back there in that corner, and in Springfield from our Deputy General Counsel, Jordan Andrew, who is hopefully raising her hand right now.
Yes.
Okay, wonderful. Thank you so much. And I'd just like to give a special thank you to the board staff for all the efforts they've put into this cycle over the last few weeks, including lots of late nights and weekends. A special thank you to Heidi Coyer, Sean Sarku, Abby Beatty, Amy Calvin, and Chris Hagar for the tremendous effort and hard work. And the most special thank you to Jordan Andrews for devoting nearly 2 months of her life to the electoral board cycle. We're hoping her son still recognizes when this is over. So with that, I'm going to begin calling objections to candidate nominating petitions for resolutions to fill vacancies in nominations for the November 5th, 2024 general election. When I call your case, you are free to come up to the front, but I will give my recommendations first. You have people under the green light. Usually under the green light is where the microphones are, so I guess we'll figure out exactly where everyone should go so that Springfield can hear us best. For the first case or two, it might take a moment to figure out where to stand, but we will work together and we will figure it out. So with that, I am going to call the first case, Hodson versus Keevan, 24 SOEB GE 100. Objector, Hodson, represented by attorneys Kevin Morphew and Michael Casper, filed an objection to the nomination papers of candidate Keevan, represented by attorney John Fogarty, and who seeks ballot access as a Republican Party candidate for the office of representative in the 112th Representative District. Objector argues that Public Act 103-586, effective May 3rd, 2024, amended Section 8-17 of the Election Code to remove the ability of established political parties to fill vacancies in nomination for offices in the General Assembly if there was no candidate for the nomination of that party in the primary. Because no Republican Party candidate for this office appeared on the general primary ballot, candidate's name, they argue, cannot appear on the 2024 general election ballot. Now, interestingly, this candidate filed his nomination papers on May 2nd, 2024, the day before the act became law. There is a question as to whether the new law applies to him. I will not be repeating that entire paragraph for every one of these cases in order to not drive everybody crazy. So hopefully you caught that, but if not, I will be here for questions. So the parties simultaneously briefed this matter. Objector argues that even after the changes made by Public Act 103-586, the election code provides candidate with 4 different ways to access the ballot, and candidate did not avail himself of that. Objector further argues that candidate cannot benefit from a preliminary injunction order that was entered by the Sangamon County Circuit Court in Colosso versus State Board of Elections, COLLAZO, Sangamon County case number 24CH32, which restrains this board from applying section 8-17 in Public Act 103586 from invalidating the named plaintiff nominating papers because, I'm sorry, the argument here is that this injunction cannot be applied to this candidate because he was not a named party to that action. An appeal of the injunction is currently pending before the Illinois Supreme Court, number 130769, and we are very hopeful that the Supreme Court will be ruling very soon. They did finally rule on a case the other day, so I'm hopeful. Objector argues that a court cannot bind non-parties, and decisions of circuit courts have no precedential value in Illinois electoral board proceedings. Accordingly, the objector contends that the board must apply a section 8-17 as it is currently written to candidates and sustain the objections. Now, the candidate argues that the Public Act does not bar him from the ballot because he filed his nomination papers the day before the act became law. The candidate claims that his right to appear on the ballot vested when he filed his papers with the State Board of Elections the day before the law became effective. The candidate cites Perry versus Department of Financial and Professional Regulation, which is cited in the board packet, interpreting the statute on statutes to argue that vested substantive rights cannot be retroactively altered absent a clear indication by the General Assembly that legislation be given retroactive effect. The candidate also adopts and incorporates all arguments made in the Colosso case. And further, candidate argues Colosso is binding upon the board in these proceedings because the board is a party to the Colosso litigation. The facts of Colosso are similar. Section 2-101.5 of the Code of Civil Procedure restricts constitutional challenges to Sangamon and Cook County Circuit Courts. And of course, this case was in Sangamon County, the Colosso case. And finally, stare decisis requires the board to follow precedent. Here, the hearing officer recommends finding the candidate filed his nomination papers on May 2nd, 2024, before the effective date of the Public Act. The hearing officer reasons that even if the Illinois Supreme Court issues an order in Colosso validating the Public Act and reversing the injunction, candidate's substantive right to appear on the ballot vested on the date he filed his nomination papers and in accordance with the law in effect at the time. The hearing officer cites to Perry, P-E-R-R-Y, as previously mentioned, which was cited by the candidate, interpreting Section 4 of the statute on statutes mean that when a law does not expressly indicate its intent as to temporal reach, a presumption arises that the amended statute is not to be applied retroactively. The Public Act does not express it has a retroactive effect, so the law applicable on the date candidate filed governs his candidacy. This permits the Republican Party to nominate a candidate to fill the vacancy in nomination and the board to render candidates' papers valid. The hearing officer further recommends concluding that although candidate is not a named plaintiff in Colosso, the board should rely on the circuit court order as persuasive authority to find candidates' nomination papers valid, invoking People versus DiGuida, D-I-G-U-I-D-A. And of course, the Supreme Court should very soon be entering its order, and hopefully will tell us all what to do in this case. We can't wait. So the hearing officer recommends, and I agree, that the board should enter a finding that candidates' nomination papers were filed on May 2nd, and the objection should be overruled, and candidate Stevens' name should be printed on the November general election ballot as a Republican Party candidate for the office of representative in the 112th representative district.
Thank you, Marnie. Mr. Casper, on behalf of the objector.
Thank you, everyone. Good morning, everyone. Michael Casper on behalf of the objector. I'm not sure where I should direct my attention, so I'll just kind of move around. In this case, the law is very clear. The plaintiffs in the Colosso case filed what we lawyers call an as-applied challenge to the law. When you file such a lawsuit, you're saying that law cannot be applied to me. It may be applicable to other people, but not to me. That's what it says. So those plaintiffs, they went to court, they got relief from the court. The court gave them what they wanted, said you, the board, cannot apply that law to those people. By very clear Supreme Court precedent, an as-applied challenge is exactly what it says. It is as applied to the plaintiff. There are 3 other cases coming up that are plaintiffs. They went to court, they won. I disagree, but they won. They were entitled to the relief that they got from the court. This candidate did not go to court. So that decision by its own terms does not apply to him. How on earth can you apply an as-applied challenge to somebody who didn't ask you to apply it to them? Didn't ask the court to apply it to them. They could have, but they didn't, for whatever reason. The plaintiffs in the case could have filed what we call a facial challenge, saying it's inapplicable to everybody, but they didn't. I don't know why they didn't. They didn't. They won the case. They, the plaintiffs, are entitled to the relief. They are the only ones that are entitled to that. Now, as to this business about the candidate filing the day before the law became effective, okay, fine. But we're here today. The board's powers are to apply the law as it is today. There's a case we cite, the Delgado case. The Chicago Board of Elections did exactly what this board and Mr. Delort attempted to do today. What they did is they said, well, there's a circuit court decision, doesn't involve us, but it involves the same issue, so we're going to follow the circuit court decision rather than the statute. The Supreme Court reversed and said the Electoral Board has no authority to do anything except apply the law. That's the law today. And so this question, General Counsel referenced the vested rights that may have attached to the candidate when he filed the papers. Okay, fine. Maybe they did. Maybe they didn't. And so the idea is if he has a vested right, applying the statute to him would violate that right. But that's not the board's authority to decide. The board's authority is to apply the law as it is today. If that violates someone's rights, then they can go to court, and a court can decide that that violates their constitutional rights. But the board has no authority whatsoever to decide the constitutionality or the constitutional application of a law. The board's authority is to apply the statute. The Supreme Court has told the Electoral Board that over and over and over again. And one of these days, electoral boards should heed that decision and heed that direction and be limited to their role. And this is apparently not going to be that case, but it should be. Thank you.
Thank you, Mr. Casper. Mr. Fogarty?
I'm happy to take any questions if anybody has.
We will in a minute after Mr. Fogarty speaks.
John Fogarty on behalf of the candidate here. Mr. Casper referenced the hearing officer's report. He forgot to include his full title, Retired Appellate Court Justice.
Well, actually, he's not a judge. Judge.
Corrected again.
They call themselves justices, but they're not.
Who knows his way around not only election law, but the law in general. And he got this one exactly right. I think the best point for this candidate is this. He was nominated by a committee, got his petitions, filed his petitions, perfected his vested right before this law went into effect. And the role of this body is, yes, to apply the law, but you also apply the law as it was when this act was taken. And you apply the law to apply retroactively when there is actual language that says you must apply this retroactively. As we pointed out in our brief, and as the hearing officer also recommended, recommended, this law, which was HB 2412, does not have retroactive effect. You cannot apply it to something that was legal before it was passed. It does not have language that would allow you to apply it retroactively. The statute on statutes supports that, and all of the case law dealing with vested rights supports that as well. If Mr. Casper would like to argue that after the fact, the General Assembly can go ahead and disallow candidacies that are otherwise valid, especially candidacies for a General Assembly seat, well, that's just incorrect. So the hearing officer is correct here. And then with regard to whether or not this board is constrained by the decision of the circuit court in Sangamon County, we believe that it is. This board was a party to that litigation. The facts are just the same, except that this candidate in this very case is in a superior position to all of those plaintiffs in Sangamon County. The Sangamon County plaintiffs, the Collazo plaintiffs, had not yet filed their petitions when this law went into effect. So the Sangamon County said, yes, applying it to these folks who had not yet filed their petitions was unconstitutional. You can't change the rules in the middle of the game. Well, you certainly cannot change them. You can't disallow a home run for someone who has just crossed the plate. And that's what Mr. Casper would do here. So we urge you to agree with retired Judge DeLorte, our general counsel, and the candidate. Thank you.
Thank you, Mr. Fogarty. Are there questions by the board?
Madam Vice Chair.
Madam Chair?
This is Chair Watson. I have a question for Mr. Casper.
State your question.
I can't see Mr. Casper. Okay, I see Mr. Casper now. Okay. So Attorney Casper, you want to tell me why Justice DeLorte or Judge DeLorte is incorrect in his decision?
Yeah, there's two reasons. Number one, I disagree with Mr. Fogarty that this candidate is in a superior position than the others. If it were me, I'd prefer to have an order from the circuit court than a timing question. But anyway, he's not a plaintiff to the case, so he's not entitled to the benefit of the injunction that the plaintiffs obtained for themselves. That's number one. Number two, the question before the board today is whether or not this candidate should be certified for the ballot today. I don't think anybody, even Mr. Fogarty, would say that the law today does not allow certification of that candidate. They're saying because he filed petitions a couple of months ago, the law today doesn't apply to him. Well, that's not the way it works. The law doesn't have a retroactive effect, but it had an immediate effect. So as soon as the governor signed the bill, it became the law. It's the law today. Today, the board has no authority to certify this candidate for the ballot. That's my answer to your question. I hope.
Thank you. Thank you.
Further questions? Do I have a motion?
Member Gray to make a motion to concur in the recommendation of the general counsel and hearing officer, overrule the objection and certify the candidate's name to the ballot.
Member Brett, second.
Roll call, Amy.
Ms. Bellercroft,
Yeah.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
No.
Motion passes.
Barney?
Next case, Hanson versus Puckett, 24 SOEB GE 500. This is the same counsel that we have here today, Mr. Casper on behalf of Objector Hansen, and Mr. Fogarty on behalf of the candidate Puckett, who seeks ballot access as a Republican Party candidate for the office of representative in the 43rd Representative District. So Objector makes the same objection as in the last case, arguing Public Act 103-586 removes the ability of established political parties to fill vacancies in nominations for offices in the General Assembly if there was no candidate on the primary ballot. And again, because no Republican Party candidate for this office appeared on the ballot, candidate's name, they argue, cannot appear on the general election ballot. Now, unlike the candidate in the last case, the nomination papers were filed when the new Public Act was already in effect. The the parties here filed simultaneous briefs in this matter, agreeing that candidate was a named plaintiff in the Colapso litigation, COLLAZO, which determines that Section 8-17 in Public Act 103-586 is unconstitutional as applied to candidate, and entered a preliminary injunction restraining the board from invalidating candidates' nomination papers on that basis. And the parties agree that the board is bound by this order. There is an understanding in this case and in the next two that the Illinois Supreme Court's future ruling on the constitutional issues in the Colapso appeal will likely decide the ultimate fate of these candidacies. Here, the hearing officer recommends, and I agree, that the board should find candidates' nomination papers were filed on June 3rd, 2024, and that the objection should be overruled and candidate Puckett's name should be printed on the November general election ballot as a Republican Party candidate for the office of representative in the 43rd Representative District.
Thank you, Monique. Mr. Casper, on behalf of the objection.
Yes, thank you, Michael Casper, for the objector. As I said in my earlier comments, the candidate in this case is a plaintiff and is entitled to the benefit of the injunction he obtained from the circuit court.
Mr. Fogarty, anything to add?
Vociferous agreement.
Is there discussion? Amy? I need a motion to make a motion to concur in the recommendation of the general counsel and hearing officer to overrule the objection and certify the candidates for the ballot.
Member Brett, second.
Roll call.
Amy, before the roll call, and Vice Chair, if you don't mind, I just want to remind the board members that you are personally bound by an injunction to allow these individuals on the ballot. So there could be court repercussions if you don't.
Roll call, Amy.
Noted.
I have a question. You say we're bound by an injunction to allow the candidate on the ballot. Can you read the injunction, please? The order of the
Absolutely. You'll have to bear with me for a couple of minutes while I find it. I've got a lot of paperwork today. Or if council happens to have it. Okay, it is. Unfortunately, it appears that the summary summary sheets are missing from my board packet. We could take 5 minutes while I print those. I apologize, I didn't prepare these materials myself.
Mr. Fogarty, Mr. Casper, do you have the order from the injunction?
Madam Chair,
I have it electronically.
Well, can you read us the order?
Yeah.
You don't know, it will take you too long to find it, is that it?
No, I can pull that right up.
And if I could ask Mr. Sarku, I think you have a computer, if you could try to pull it up as well, I would greatly appreciate it.
we have it right here. Okay, John?
Mr.
Great, who's
Brett,
speaking?
then, can you read us the order?
Yes, Madam Chair. I will read only from the order provision.
Raise your voice, because I can't hear you.
Raising my voice, I am, reading only the operative, portion at the end, not the entire decision. Paragraph 1 of the order says, plaintiff's emergency motion for TRL.
Okay, I can't hear you at all. So let's, Mr. Fogarty, if you read it, maybe I can hear you.
No.
Or perhaps we could pass the microphone to Mr. Brett?
You've got the mic.
He's right on it, Marty.
Oh, okay, my mistake.
Bottom of page 4, Mr. Fogarty.
Not sure. Thank you. All right. Bottom of page 4, you would like?
I like the words that the board is enjoined
Okay.
and
well, that's
must allow these candidates on the ballot.
Will you just take my word for it, member Watson?
No,
Good. Okay.
Let me try again. Paragraph 2. Defendant State Board of Elections and defendant Kwame Raoul are preliminarily enjoined from rejecting claims
I
nomination.
can't hear the words clearly. Mr. Brett, I'm sorry. Mr. Fogarty, come on.
I will start with the relief that is ordered. Declaratory and injunctive relief is entered as follows. The revisions to 10 ILCS 5/8-17 contained in Public Act 103-0586 are unconstitutional as applied to plaintiffs in the November 2024 general election because the application of the amendment to plaintiffs during the 2024 election cycle impermissibly burdens their right to vote and to have their names placed on the November ballot. The timing of the amendment, which eliminated one of the methods for ballot access that was available at the beginning of the cycle after the March primary election had taken place, precludes plaintiffs from having their names placed on the November ballot under any statutorily available method. The challenged amendment as applied to plaintiffs in the 2024 election cycle places a severe restriction on the fundamental right to vote, and therefore the proper standard is strict scrutiny, which it does not meet. The law which became effective May 3rd, 2024 is applied to plaintiffs in the ongoing 2024 election. I'm going to skip to the last paragraph. With respect to injunctive relief, based on the court's declaratory judgment regarding Public Act 103-0586's revisions to 10 ILCS 5/8-17, the defendant State Board of Elections and defendant board members are hereby enjoined from applying the provisions of Illinois Public Act number 103-0586, which revised 10 ILCS 5/8-17 to eliminate the slating process for General Assembly elections as a basis for denying plaintiffs nominating petitions for the November 2024 general election and from otherwise using the revisions to prevent plaintiffs from being listed as candidates on the November 2024 general election ballots.
Thank you.
Thank you. Any further discussion, Cassandra?
That's it for me.
Roll call.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Present.
Motion passes.
I can do that.
Madam General Counsel?
Next case, Ishmael versus Alexander, 24 SOEB GE 501. This case is the exact same case as the last case, except the objector is Objector Ishmael, and the candidate is candidate Alexander, who seeks the Republican Party to be a Republican Party candidate for the office of representative in the 50th Representative District. The hearing officer recommends, and I agree, that the board should enter a finding that candidate's nomination papers were filed on June 3rd, 2024. The objection should be overruled, and candidate Alexander's name should be printed on the November general election ballot as a Republican Party candidate for the office of representative in the 50th Representative District.
Do you two gentlemen have any comments? Mr. Casper, Mr. Fogarty, anything to add?
No, thank you. And none here either.
Discussion? If not, do I have a motion?
Member Cray for a motion to consider the recommendation of the general counsel and hearing officer to overrule the objection and certify candidate's name to the ballot.
Member Turbin seconds the motion.
Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Present.
Motion passes.
Madam General Counsel, next case.
Thank you. Next case, Basinger versus Bear, 24 SOEB GE 503. This is once again the same set of facts, only our objector is Basinger and our candidate is Bear, who was also a plaintiff in the Colossus case. In this case, I actually recommend supplementing the hearing officer's recommendation with a finding that the candidate's nomination papers were filed on May 3rd, 2024 at 8:41 a.m., the same day Public Act 103-586 was signed into law. In addition, the hearing officer recommends, and I agree, that the objection petition should be overruled and candidate Bear's name should be printed on the November general election ballot as a Republican Party candidate for the office of representative in the 57th Representative District.
Is there discussion? Well, let's wait. Gentlemen, do you have any more comments? Mr.
No, thank
Casper,
you.
Mr. Fogarty? Is there
No.
discussion? Do I have a roll or a motion?
Member Cray makes the motion to concur in the recommendation of the general counsel with her supplemental comments and the recommendation of the hearing officer to overrule the objection and certify the candidate's name to the ballot.
Member Brett second.
Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Present.
Motion passes.
All right, thank you. Madam General Counsel.
Thank you, gentlemen, and I believe that was all of your cases.
Oh, okay, thank you very much. Thank you.
Yes, there were so many, but that does complete our vacancy and nomination cases. We're now moving on to consideration of objections to new party and independent candidate nominating petitions for the November 5th, 2024 general election. The first case is Kopel versus Asanye, 24 SOEB GE 101. Objector Copel, represented by attorney James Morphew, filed an objection to the nomination papers of candidate Osanye, who is represented by attorney Scott K. Summers, and who seeks ballot access as a Green Party candidate for U.S. Representative for the 13th Congressional District. Objector argues their objection should be sustained and candidate removed from the ballot because she submitted insufficient signatures. Section 10-2 of the Election Code requires a minimum of 12,710 signatures for this office, and candidate submitted 1,557. The hearing officer recommends, and I agree, that the objection should be sustained, and candidate Osanye's name should not be printed on the November general election ballot as a Green Party candidate for the office of U.S. Representative for the 13th Congressional District.
Thank you, Jen. Go ahead.
I'm sorry, no council is present up there, so I'm wondering if council is present in Springfield?
Do we have anyone here? No, we don't. Do I have a motion?
Oh, I'm sorry, we did just have an attorney step up. If you could introduce yourself, sir.
Good morning, members of the board. Jim Morphew on behalf of the objector in this matter.
Go ahead, Mr. Morphew.
We simply are here to urge the board to adopt the recommendations of the hearing officer and the general counsel. The candidate is far short of the number of signatures required for ballot access.
Thank you. Do I have any discussion? If not, a motion?
Member Turbin, I make a motion, hearing officer's findings and recommendations with concurrence of the general counsel.
Member Brett, second.
Did you get that? Roll call, Amy.
Ms. Bellercroft,
Yeah.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson,
Yes.
motion passes.
Next
Thank you.
case, Marnie?
And I apologize if I mispronounce the same, Pyle or Peel versus Delacruz versus Oakley, 24 SOEB GE 507. The objectors are represented by Ed Mullen and filed an objection to the nomination papers of candidate Oakley, represented by attorney Christopher Kruger, and who seeks ballot access as an independent candidate for U.S. Representative for the 3rd Congressional District. Objectors argue their objection should be sustained and candidate removed from the ballot because he submitted insufficient signatures. Section 10-3 requires a minimum of 9,126 signatures for this office, and candidates submitted 8,399. The candidate filed a verified motion to strike and dismiss objector's petition, primarily challenging the signature requirement here as unconstitutional, and objectors opposed the motion. The hearing officer did not recommend a ruling on the motion, so I will do so now. I recommend denying the motion because the validity of the statutory signature requirement is beyond the board's powers. Administrative agencies, including electoral boards, have no authority to declare statutory requirements unconstitutional or even to question their validity. And I'm citing that the case of Goodman versus Ward. It's an Illinois Supreme Court case from 2011, and it is cited in your packet many, many times. Candidate also objects to the use of a staff signature count as hearsay and to the minimum statutory signature count as incorrectly calculated, however, without any elaboration of the argument. To the extent dismissal is sought on these two bases, neither objection challenges the validity of the objector's petition. The staff count is provided in accordance with the rules of procedure and could have been challenged, and the motion should be denied in full. The general counsel otherwise concurs in the hearing officer's recommendation that the objection should be sustained and candidate Oakley's name should not be printed on the November general election ballot as an independent candidate for the office of U.S. Representative for the 3rd District.
Thank you, Marnie. Is there discussion or no, excuse me. We have their attorneys. Could I have the attorney, Mr. Mullen, for the objector? Objection?
Did you wanna?
Christopher Kruger on behalf of candidate.
The objector normally gets to go first.
So, this is a very simple objection. The candidate did not file enough signatures and should not be on the ballot because they did not file enough signatures. We have some arguments related to the validity of the signature requirement, which, as this board has repeatedly ruled, is outside the scope of the board. We have questions about the calculation, but even using the calculation provided by the candidate did not have enough signatures and provided no basis for that alternate calculation. And finally, the staff count is accounted for by the rules and is not hearsay. So for all those reasons, the objection should be granted.
Mr. Kruger?
Yes, so on behalf of candidate, we want to stress the fact 8,400 Illinois citizens signed petitions for this candidate. The requirement is 30 times that of an established party candidate of 277 signatures. That shocks the conscience. You don't need to be a constitutional scholar to be shocked by that. This is governed by the Elections Clause, which, when you have a federal office, it's a very different situation than these state offices. So the federal office is governed by the Elections Clause, and this board should tread carefully. There is no rational basis that, and the Central District, U.S. District Court in the Central District of Illinois already held this in the guilt case, that the 5,000 signatures that suffice in a redistricting year should suffice in every year. And that's just a plain matter of fundamental fairness and equity, and does not require any high degree of scholarship, and it is within the power of this board to vindicate 8,400 Illinois citizens versus one objector, one political operative as an objector filing a objection under this private challenge system, which is also, the private challenge system has been found unconstitutional. So that's all for the candidate, and thank you very much. It's a privilege to be before this board. Thank you very much.
Thank you, Mr. Kruger. Is there discussion? Any questions? Do I have a motion? Do I have a motion?
I move to accept the recommendations of the general counsel and the hearing officer and grant the objection.
Second?
Member Turbin, second that motion.
I apologize. The motion is from Member Brett.
Mr. Brett and Mr. Turbin have made a motion. Amy, roll call.
Ms. Ballarcroft?
Yeah.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes?
Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes?
Chair Watson?
Yes.
Motion passes.
Barney?
Thank you, council, and thank you, Madam Vice Chair. The next case, Fiedler versus Schluter and Green, 24 SOEB GE 505. Objector Fiedler, represented by John Fogarty, filed an objection to the nomination papers of candidates Fiedler and Green, represented by attorney Daniel Scheel, SHIELL, and who seeks ballot access as Libertarian Party candidate for President and Vice President of the United States. Objector argues the objection should be sustained and candidates removed from the ballot because they submitted insufficient signatures. Section 10-2 requires a minimum of 25,000 signatures, and candidates submitted 4,044 signatures. The hearing officer recommends, and I agree, that the objection should be sustained, and candidate Schluter and Green's names should not be printed on the November election ballot as Libertarian Party candidates for the offices of President and Vice President.
John Fogarty for the objector.
Go ahead, Mr. Fogarty.
We agree with that recommendation.
All right, do I have any discussion? Is there a motion?
Motion by member Cray to concur in the recommendation of the general counsel and hearing officer to not certify the names to ballot.
Member Turbin, second that.
And if I may, quickly before a roll call, can, Springfield confirm that Attorney Daniel Shield is not present?
Yes, we can confirm he is not present.
Thank you.
Amy, roll call?
Ms. Ballard Croft,
Yeah.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes?
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes?
Chair Watson.
Yes.
Motion passes.
Thank you. Next case, Duffy and Kuski versus Stein and Kapadanu. I apologize for a mispronunciation. 24 SWB GE 507. Objectors Duffy and Kuski, represented by attorneys Ross Seckler, Stephen Ladazinski, and Priscilla Centeno, filed an objection to the nomination papers of candidates Stein and Kapadanu, who seek ballot access as a Green Party candidate for President and Vice President of the United States. Objectors argue their objection should be sustained and candidates removed from the ballot because they submitted insufficient signatures. Section 10-2 of the Election Code requires a minimum of 25,000 signatures, and candidates submitted 8,627. The hearing officer recommends, and I agree, that the objection should be sustained, and candidates Stein and Kapadanu's names should not be printed on the November general election ballot as Green Party candidates for the offices of President and Vice President.
So I'll have to pause.
I'm hearing some background noise. Oh, okay, I'm sorry.
Yes. Just hang tight for a minute. I apologize. Just pause. 5 minutes.
Just to let everyone know, we have 5 members present in board offices today, so anytime a board member needs to step out of the meeting, we need to take a break until they come back.
So since we're on a break, I must ask, the purpose of public comment is to give public advice to the hearing or to simply comment after you've already made a decision?
You'll have to comment after we've already made a decision.
How is that? I mean, I know we have 5 minutes, if I'm out of order, but how does that work?
All right, we are back, in session. Marnie, do you have anything further, or should I go to Mr. Seckler?
Very briefly, I just wanted to respond to someone in the audience. The parties have attorneys here to represent them, and the general public is not their representatives, but of course, you are, welcome to give your comments when that time comes. That time is written in the agenda, and it will be coming up in not too long. Now, Mr. Brett, did you hear the rest of my recommendation?
Did you hear?
Do I need to repeat any portion of my recommendation?
No, I heard everything. I thought we completed voting and I stepped out to use for a personal comfort break. And I forgot that we needed my presence physically in the room for a quorum. So I apologize that there's be so much discussion of my bladder in the minutes.
Well, after this case, we're going to talk about my bladder and taking a 5-minute break. You are in good company. And Mr. Seckler is here.
All right, Mr. Seckler, would you please start?
Thank you, Ross Seckler. On behalf of the objectors, we agree with the recommendation of the hearing officer and general counsel.
All right.
And I can confirm no one is here on behalf of candidates up in Chicago. Is anyone there in Springfield?
Is there anyone here for Ms. Stein? All right. Do we have discussion? Any comments?
Member Cray, on the motion to concur in the recommendation of the hearing officer and general counsel to grant objectors motion for summary judgment and sustain the objection.
Member Turbin, second that.
Amy, roll call.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passes.
Okay.
And now, if I may request a 5-minute break. I would greatly appreciate it before I begin doing all of the talking.
No problem, Marnie. We'll take a 5-minute break.
Thank you.
Oh. Are we about ready up there? You're muted. All right, we'll reconvene and call the next case. Marnie?
Vice Chair Donahue, if you could give us about 2 more minutes, I think
Okay.
there's counsel on the next case is not back yet, so 2 minutes would be appreciated.
No problem.
Thank you.
Awesome. Are we ready?
We are ready.
All right. I will, Marnie, if you would begin.
Okay, this is our final electoral board case for the day, although we have many campaign disclosure cases left to hear. Duffy and Kuski versus Kennedy and Shanahan, 24 SOEB GE 508. This is quite a lengthy recommendation as it's a very nuanced objection. So I hope everyone will bear with me. I hope I can get through it in 15 or 20 minutes, but no promises. So objectors Duffy and Kuski, represented by attorneys Ross Steckler, Stephen Ladizitsky, and Priscilla Centeno, filed an objection to the nomination papers of candidates Kennedy and Shanahan, represented by attorneys Andrew Finko and Christopher Kruger, and who seek ballot access as independent candidates for President and Vice President of the United States. Objectors argue their objection should be sustained and candidates removed from the ballot because they submitted insufficient signatures after considering individual petition signature objections, notary and circulator objections, and a pattern of fraud. Objectors also claim candidate Kennedy filed a false statement of candidacy, that the candidates are not independent under Illinois law, and objections to candidate Shanahan's name not appearing on the petition sheet submitted. Candidates filed their motion to dismiss objector's petition for lack of jurisdiction and seeking dismissal of specific paragraphs of the petition, including dismissal of paragraphs 35 through 44, which allege candidates are not true independents and is engaged in party switching. Now, on the issue of jurisdiction, candidates argue that the objection should be dismissed in its entirety because the electors for president and vice president who will vote in the Electoral College rather than candidates Kennedy and Shanahan are the real candidates and the real parties in interest here. Section 10-5(3) of the Election Code provides that the names of the presidential candidates to whom the electors have pledged their votes are optional, but may be added to the petition sheet. Additionally, Section 2A-1.2 of the Election Code lists the electors for president, not the candidates for president, as the offices to be voted upon this year. They argue candidates were not required to submit statements of candidacy, although they did do so. Candidates also argue the board lacks jurisdiction over candidates' electors because objectors failed to name them in their objection petition, and electors have not been served or afforded due process. They argue the failure to name the electors deprives the board of jurisdiction over this entire case. The hearing officer recommends that the motion to dismiss portion of alleged lack of jurisdiction should be denied, mostly for the reasons argued by the objectors. The hearing officer recommends finding that candidates' arguments would require reading exceptions into various provisions of Article 10 for presidential candidates that do not appear in the plain language of the statute. And as argued by objectors, Section 21-1B of the Election Code also provides that it's the candidates' names who will appear on the ballot in November in lieu of the names of the electors. Although the board does not have jurisdiction over the electors, as they were not named in the objection petition or served in this matter, this does not deprive the board of jurisdiction over the filings that were made by candidates Kennedy and Shanahan. Under Illinois law, even failure to name necessary parties does not destroy jurisdiction if a party before the court effectively represents their interests as the candidates do here. And that is a cite to Klingel, Klingel versus Kerrer, Kehrer, and which is cited in your packet. As to the motion to dismiss, paragraphs 35 to 44, the hearing officer recommends granting the motion because although candidates have associated with other political parties outside the state of Illinois this year, those activities do not constitute prohibited party switching under Election Code Section 7-43. The hearing officer further recommends denying the remainder of the motion to dismiss individual paragraphs of the objection petition. A record examination was conducted in this case from July 12th through July 18th. Candidates filed 65,882 signatures. Objectors objected to 3,614 lines. During the exam, 22,842 line objections were sustained and 10,772 line objections were overruled, resulting in 43,040 remaining signatures. Both parties filed Rule 9 motions, and the results of the Rule 9 motions did not change the results of the records exam. Next, 3,897 pages were objected to based upon dual circulation violations and or a pattern of fraud or some other individual page issues. So following an examination of the identified petition sheets, the recommendation is to strike 2,140 of the objected petition pages containing 9,734 additional signatures, resulting in candidates having filed 33,286 valid signatures, which is still over the 25,000 required. I will talk more about these issues below. So finally, 6 days of hearings were held until 7 p.m. every day, concluding last Friday, August 16th. Witnesses testified, including handwriting experts on both sides. Following the hearing officer recommends adopting the results of the record examination and examination of specific petition pages objected to and detailed in Exhibit E to the hearing officer's recommendation. So 2 legal issues remain that I'd like to give attention. The first is an alleged false residence address. Objectors allege that candidate Kennedy's candidacy should be invalidated because he provided an allegedly false residence address on his nomination papers, specifically on his statement of candidacy. The hearing officer reaches the conclusion that candidate Kennedy did in fact falsely swear to residing a New York address that is not his true address, relying upon a trial transcript of the New York case of Cartwright versus Kennedy, cited in your packet, including the sworn testimony of candidate Kennedy in an affidavit that was submitted, and the Cartwright opinion finding that candidate Kennedy is not a New York resident. Finally, the hearing officer recommends drawing a negative inference from candidate Kennedy's failure to appear before the hearing officer pursuant to Illinois Supreme Court Rule 237. There was a notice of parties to appear, and this is also required by the rules of procedure. This negative inference is permitted under the case of Muldrow versus Barron, MULDROW versus Barron, BARRON, which is cited numerous times in the hearing officer's recommendation. However, the hearing officer opines that this falsity is not fatal to candidate Kennedy's candidacy. Illinois case law considers errors or omissions within nomination papers to be fatal to a candidacy if they thwart the purpose of the election code or result in voter confusion. Here, the same New York address is provided in the statement of candidacy and throughout the petition sheets, which the hearing officer says prevents voter confusion. And the purpose of the election code is arguably not thwarted by this result either, because under case law, the purpose of a statement of candidacy is to swear to a candidate's eligibility for office, and candidate Kennedy is indeed eligible for the office of president under the United States Constitution. The hearing officer reasons further that the petition sheets are not falsely sworn, as candidate Kennedy did not sign the petition sheets. Finally, despite objectors' citation to a persuasive Chicago Electoral Board case, Collier versus Robertson, COLLIER and ROBERTSON, the citation of which is in your packet, the courts have only authorized a candidate's removal from the ballot if the statement of candidacy's falsity affects their eligibility to hold office, which the New York address does not, citing to Goodman versus Ward, which will be cited multiple times today. Therefore, the hearing officer recommends overruling the objection to alleged falsity of the statement of candidacy. Next, objectors' allegations that candidate Shanahan should be denied ballot access because she filed no petition signatures, as raised in paragraphs 35 to 44, should be overruled. Section 10-5 provides the name of candidates for president and vice president may be added to the petitions for nomination. So listing the name of the vice presidential candidate on the petition sheets is optional, as argued by candidates. The objections raised in paragraphs 45 to 47, alleging voter confusion will result because candidate Shanahan's name is not printed on the petition sheets, should also be overruled. As her name appears on her statement of candidacy, the nomination papers may be viewed as a whole so that no confusion will result and no violation of the election code occurred. The hearing officer's report includes a short summation paragraph reiterating the results of the records exam and petition sheet review and recommending that the objections be overruled and the candidates' names appear on the ballot. Now, I agree with the recommendations of the hearing officer as supplemented with 2 points. First, I would like to add a clarification summary of the rulings on the objections, indicating that paragraphs 35 to 44 were dismissed in response to candidate's motion to dismiss and not on the merits. Additionally, paragraphs 5 through 10, 14, 15, 17, 19 through 21, 23 through 25, and 27 to 34 were sustained in whole or in part. The objections in the remaining paragraphs were denied. My second point is that a ruling on objector's paragraph 14 appears to be missing from the hearing officer's recommendation. This paragraph alleges deficiencies in specific petition pages. And on that issue, I would recommend adopting the findings contained in Exhibit E of the hearing officer's report, showing each specific ruling. Where the identified petition sheets were materially deficient and thus violate the provisions of Section 10-4 of the Election Code, I recommend that those sheets be stricken. Overall, I recommend first, granting candidate's motion to dismiss objector's petition as paragraphs 35 to 44 and denying the remainder, sustaining in part and overruling in part the objection of Duffy and Kutzke to the nomination papers of Kennedy and Shanahan as set forth above, and that the names of Robert F. Kennedy Jr. and Nicole Shanahan be certified to the November 5th, 2024 general election ballot as independent candidates for the office of President and Vice President of the United States, respectively. Yesterday, both sides filed exceptions pursuant to the rules of procedure, and copies of those exceptions have been provided to the board. Upon reviewing those exceptions, none of them have changed my recommendation in this case. I can assure you the board has been given vast amounts of materials in this case and have been told to read them carefully. So I'll turn this over to the attorneys in just a moment, but please know you don't have to reiterate all of your arguments. The board very well knows, and I strongly emphasize the need to read all of the materials here.
Thank you, Marnie. And yes, I would reiterate what Marnie just said. We have had volumes of information regarding this as regard to many of the recordings of the hearings. So I think it's 10 minutes for each side. So if you want to begin, Mr. Seckler, please begin.
Madam Chair, excuse me, Mr. Seckler, Madam Chair, if I could ask a question.
Yes, ma'am. Madam Chair.
Mr. Counsel for Mr. Kennedy. Is your client dropping out?
That's beyond my pay grade. I'm sorry, I don't know. I'm here for the electoral board and that's it.
So
we have no idea.
You haven't had any communication with your client saying that all of this time that we're taking is unnecessary?
I've had a lot of communication with my client, but that is privileged. And at this point, I think, you know, we have to proceed. This objection was dead in the water from day one because they named the wrong people. But Your Honor insisted on proceeding. So it wasn't my decision to proceed, Your Honor.
Thank you. I'm sorry, Mr. Seckler.
I'm sorry, Mr. Seckler, as well. Madam Vice Chair, if you could please remind the audience that they're to remain silent except during the public comments portion, I would appreciate it.
I will ask that everyone that is in our audience to remain quiet until you have your chance during the comment period. Mr. Seckler, the floor is yours.
Thank you very much, Ross Seckler, as well as Steve Planazinski is here on behalf of the objectors. And obviously, this is a very complicated case with a lot of different facets and issues. It's with a 6-day evidentiary hearing, many filings and responses, and having to deal with a lot of different issues here. And that obviously there's a lot of passion in the room. But when it boils down to it, I'm going to make this very simple. We're going to talk about one issue today where the hearing officer respectfully and with respect to the general counsel, simply have gotten it wrong. They got it wrong on the law, not the facts. And that's important because with the hearing officer, over 6 days of hearing and through all the exhibits, he examined the facts, saw the facts, and understood what was going on, and especially with respect to the candidate refusing to appear, even with accommodations to appear by Zoom or anything else, refused. So he made factual findings, which are correct. And the factual findings are clear. Candidate Kennedy lied on his statement of candidacy. He falsely swore that he lives in a state and an address that he doesn't. He doesn't. He lives in California with his wife, his children, his various pets, etc. Why he did this? There's a lot of different reasons, and there should be negative. The error in the facts is that the negative inference should have included that, as was alleged in the objector's petition, and that he should have been found to be lying in order to avoid the effects of the 12th Amendment and the inability for two candidates to be from the same state and receive that state's electoral college vote, as well as for various political purposes, tying himself to the state of New York falsely. But the key is, the Illinois Constitution gives the General Assembly the power to enact laws to, among other things, protect the integrity of the electoral process. Part of those laws requires in Section 10-4 and 10-5 that the petition sheet and the statement of candidacy include the residence address of the candidate. And it says it in 10-4, and then 10-4 says if you don't do this, petition sheets aren't valid, none of the signatures are valid. It says it in 10-5, where it says the petition sheets have to have the residence address of the candidate, and then it says that a statement of candidacy has to be filed and sworn to under oath. Under oath, that includes the address of the candidate. It's a really basic requirement. Candidate Kennedy, in this case, didn't do that. He lied. He falsely swore. And the hearing officer found it. A court in New York has found it, and other courts are currently finding it. But he refused to testify in this case. We have to assume that had he testified in this case, in order to not further perjure himself, he would have had to testify against his interests. And therefore, he would have testified that, yes, he lied on his statement of candidacy. And he did it for nefarious purposes. That is what happened, and that is what the hearing officer found. The problem is that the hearing officer says it's no problem. What do we do? It's no problem. He lied. The entire thing that he signed in front of a notary public, signed under oath, subject to perjury, committing perjury, and it's of no effect. Well, respectfully, that is incorrect. Here, we have false swearing as to a material element of the statement of candidacy. It's been found. We're not even willing to go into the residency discussion. It's been found. And so he is sworn to that. It is as if, at the very minimum, it's as if he didn't give an address at all. And it's as if that was blank on either the petition sheets or on the statement of candidacy. And he just didn't do that. But more so, the false swearing goes to the entirety of the document itself. And if we've cited case law in the briefing, and I will not belabor the point, and I will spare this board some of that because I trust that you have all read all of the mountain of pleadings, but in particular the exceptions that we filed yesterday, less than 24 hours after receiving the hearing officer's recommendation. And the key is, the election code doesn't contain any of these exceptions that the hearing officer has created to alleviate this burden, any burden on the candidate here. It doesn't say, well, if your residence doesn't apply to the office that you're seeking, or it doesn't really matter for your eligibility requirements, well then it's okay. You can lie. You can make an address up. You can use a PO box or something. It doesn't say that, and it doesn't say that for a reason. And the General Assembly would have provided an exception to presidential candidates, congressional candidates, to federal candidates, to anyone else where an office doesn't necessarily require a residency duration or a specific residency, if they wanted that exception to be there in the 3 places that are relevant to this case, for requiring you to put your address, had they wanted that to be there, they would have put it. There is no exception in the statute for candidate Kennedy to have lied, committed perjury, is by clear and convincing evidence, and then just walk away and be on the ballot. And that's really the crux of what we're saying here is on a policy level, if this board were to adopt this decision, it really would open the floodgates of anyone would be able to say, well, my address is just being able to not provide an address or to lie about your address. And it really does impugn the integrity of the electoral process to allow a falsely sworn to document. One document we have from every candidate trying to seek access to the Illinois ballot that says it is sworn to, and it says, this is me, I'm qualified, this is where I reside, and please place my name on the ballot. If that document is invalidated, that sworn oath, which has been found to be mandatory, required, absolutely. Many candidates get kicked off the ballot because they forget to sign that statement, because they forget to get it signed before a notary or someone able to take an oath. Many candidates, that happens often. In this case, the candidate swore in front of a notary, but he falsely swore, committed perjury. And therefore, to allow it to stand simply because other cases that have removed candidates from the ballot have reason that it had to do with the qualifications for the office does not apply. They don't say it only is that basis, it's only that reason. That was the basis of that objection, that specific case. For example, Goodman versus Ward being in a sub-circuit for a judicial sub-circuit. That is part of the qualifications for the office, but it's also about lying under oath.
You have 3 minutes, Mr. Steckler. 3 minutes.
The Collier case we cited was affirmed by the Circuit Court of Cook County, and that went into is one of the cases that goes into that it doesn't go to the qualification when you falsely swear under oath. The document, the statement of candidacy, is void. And this wasn't in the recommendation. Notice it was framed as an error or omission. This isn't an error or omission. This isn't a mistake. This isn't Ryan versus Landeck transposing a couple digits or something like that in your address, or getting something wrong, or even him being mistaken that he couldn't use a property that he owns. He owns other property. He could have used the Massachusetts property, other California properties. He didn't. Why? For various political machinations and reasons, and also for the 12th Amendment issue with respect to California. But he didn't. He lied. He lied. He says he lives and resides in a spare 1-bedroom apartment where he intends to move all of his things, his family, wife, children, all of his exotic pets, everything into this one room. He said that under oath. So, and that was found to be absolutely incredible, of course, and that's the finding in this case. The issue is he lied. And to be able to allow that improper, we would respectfully request that the board reject that portion of the hearing officer's recommendation as well as the general counsel's recommendation and sustain the objections against candidate Kennedy.
Madam Vice Chair, may I make a quick statement for the record?
You may.
I just wanted to note that on behalf of objectors here, in addition to Mr. Steckler, we have Mr. Ladazinski standing up here. And I also wanted to note that for candidates, we have both Andrew Finko and Christopher Kruger standing up here, who, just because they're not speaking, I wanted to make sure that, or some of them may not be speaking, I wanted to ensure they're all acknowledged in the record. And with that, I will turn this over to Mr. Finko.
Yes. All right, thank you, members of the board. Appreciate the time to be able to address you this morning. I have to say, I am deeply shocked. I am deeply dismayed to hear Mr. Steckler go so far out on a limb with his argument about residence and statement of candidacy. He knows better. This electoral board should also know better based on its attorney's advice. There is no residence requirement for a president of the United States who is the person who will ultimately seek to hold that office. Everybody knows that. That's covered by the Constitution. Everybody also knows that Illinois cannot regulate any qualifications for the ultimate candidate for president. That's something that is defined by the U.S. Constitution. The U.S. Constitution gives the qualifications of a citizen and a resident for 14 years of the United States and 35 years of age. There's not much else that a state can do, and there's plenty of case law that's cited in the briefs. The Trump versus Anderson case from Colorado. Colorado tried to pull a New York move, like the way New York recently challenged its rights and overstepped its bounds under the Constitution. Colorado tried to remove President Trump allegedly for the insurrection of January 6th and his involvement in that. The Supreme Court, in a unanimous decision, says the states don't have any rights to enforce any of the constitutional provisions, the qualifications or the requirements or restrictions on a candidate who will ultimately hold the office of U.S. president. So, you know, and that's the law. The U.S. Supreme Court says the state cannot do any of this, and it's because we're talking about the ultimate candidate for U.S. president and vice president. Now, they're off limits because they're not even on the election ballot in Illinois for voting purposes. Now, we have a lot of confusion, I think, among everybody here, and it's not common knowledge, perhaps, that the election code contains very significant provisions that define who can be on the Illinois ballot. And I did want to address that the hearing officer did get a number of things correct. So the Illinois ballot for the general election lists the offices that are actually elected. Now, this is the technical legal version of the election code. So the technical legal version of the election code says, and this is in the section 2A-1.2, the following offices shall be filled or shall be on the ballot or as otherwise required by this code. Number one, elector of the president and vice president of the United States. It also goes on, United States Senator, United States Representative, United States State Executive Branch, State Senator, State Representatives, County, Circuit Court, Regional Superintendent, Trustees of the Water District. There's a full list of each and every candidate that will be filled, each and every office that will be filled at the ballot. Nowhere on the list in the election code does the office of president or vice president of the United States get elected at the November 5 general election. To repeat, section 2A-1.2A1 of the election code says that the following offices shall be filled and that's the elector of president and vice president of the United States. So when everybody says, oh, you know, this candidate's name will be on the ballot, and we're going to vote for that name, whether it's Robert F. Kennedy Jr. and Nicole Shanahan, whether it's Kamala Harris and Tim Walz or Donald Trump and J.D. Vance, that's the names that we'll see in brackets. Now, the argument from the Objectors Council here is the layperson salesman argument. It's the puffery saying, oh, but we see their names on the ballot and it's in brackets, so therefore they are on the ballot. That's utterly false. And it's utterly false because the election code says that the offices of president and vice president are not offices that are filled, and that's the 2A-1.2, are not filled November 5. We have an electoral college process. The electoral college will meet and vote December 17, and that's on a separate ballot for president and vice president. So Illinois elects its electors. The elector candidates are the ones that submitted the nomination papers. And if we look at the Kennedy petition sheet, the name of Robert F. Kennedy is printed at the top. But that name is as a pledged candidate, and that's identified in paragraph below that. The paragraph below that says, and this is from the petition sheet that many of us have circulated and seen. This is the petition sheet that this electoral board decided to review. The review in absentia, the elector voters, and it says, we, the undersigned qualified voters of the state, do hereby petition the following named persons shall be an independent candidate for election to the office herein specified to be voted at the general election. It says the following Illinois residents are candidates for the offices of electors of President and Vice President of the United States, pledged to the above named candidate. So the 19 electors who were not served with a copy of the objection, who are not named in the objector's petition, but yet they're the ones whose paperwork was subjected to review. That's the problem that I had with jurisdiction, that they're not even here. And no, I'm not representing them. And no, it's not right to deny somebody their constitutional rights without them being present. We could just have every election case reviewed by a hearing officer and let the board decide what's the point of having the candidates served, first of all, and the candidates present. In absentia is what the danger of this electoral board's decision. Now, so setting the vernacular aside, I mean, the fact that bracketed names of a candidate for president and vice president will be on the ballot does not make it so. And it does not make it so because the election code expressly says what offices are on the ballot, 1.2A1, and then it says in the printing of the ballots, this is the section that Mr. Seckler relies heavily upon. Oh, but their names are on the ballot. Yes, it's a convenience feature that says rather than having 19 electors for the Democratic Party, 19 electors for the Republican Party, 19 electors for independents, 19 for any new parties, we're going to have just 2 names written in brackets. And the election code is plain and clear, and it says a vote for that name, that grouping, means a vote for each of the 19 electors. It cannot be more clear. So at no point can a president, such as whether it's Biden or Harris, or if it's Trump or Kennedy, anybody else, they are not voted upon by the voters directly. The popular vote goes to the electors, and that's clear in the election code. So the argument about, oh, but his name is on
2
the
minutes,
paper and bracket.
Mr. Finko.
Okay, thank you. That's a false one. So the hearing officer got some things correct, and I did want to compliment him. So this is page 78 of his 82 page. So it's toward the end. He got it right at the end. And he did talk about established political parties. So established political party means under Illinois law in 10-2, and that's at page 79. Now, the important part, and this is addressing the statement of candidacy and residence. Statement of candidacy only governs the offices that are filled at the election, and that's that 1.2A. So the office of president and vice president isn't on that list. Therefore, there's no statement of candidacy requirement and obviously no residence requirement. Now, the hearing officer did recognize this. This is at page 79 and 80 of his report. And he did say section 2A-1.2A of the election code designates 12 offices to be filled at the appropriate even numbered years and does not specifically designate the office of vice president of the United States as one of those offices. The electors of president and vice president are the office to be filled. And then it says the names of the candidates for president and vice president may be added to the petitions, not must. Thus, and this is a very important part, thus, the name of a vice presidential candidate cannot be read into section 10-3 of the election code such that the remedy sought by objectors, removal of the candidate Shanahan's name, cannot be granted.
30 seconds, Mr. Finko.
If you read that together, the same applies for president. So there's no way that the name of Kennedy or Shanahan can be removed from this ballot because it's the electors who are on the ballot, who are always on the ballot, and will be on the ballot regardless of what Mr. Kennedy may decide to do. Thank you.
Is there discussion or questions? Oh, excuse me. I'm Mr. Seckler. I think I should give you an opportunity, 2 minutes to respond.
Sure. I think I think what Mr. Finko, this is Steve Ledzinski on behalf of the objector. I think what Mr. Finko is missing is Illinois law has requirements for individuals that are going to have their names printed on the ballot. And those requirements are, you must provide a statement of candidacy that has your name and residence address. We have the candidate here under oath admitting that he lived in California, which is not the address on his statement of candidacy or his nomination papers. This is an attack on the electoral process. The purpose of the sworn statement is to be the gatekeeper. This statute, which federal law allows every state to have laws in place to allow this board and the state to govern who gets ballot access. What Mr. Kennedy did is very simple. He lied. A false statement was submitted. If candidates are not allowed to be printed on the ballot where they forget to put their address in, a sworn statement that is false and perjurous must be stricken. That's for the protection of the electoral process. All these 63,000 signatures, which ultimately get down to about 30,000 signatures on these petition pages, have an address for Mr. Kennedy that is not his residence address. He doesn't live in New York. He lives in California. And that is where the fraud is upon the electorate and this board.
Thank you, Mr. Ledzinski. Do we have questions? Discussion? Marnie, do you have any further comments?
I'm happy to answer questions, but I think you all have read a lot of paper, and these attorneys have given lots of arguments on their clients' behalf. Comments from?
Do I have a motion?
If I could mention that when a motion is made, if it is to accept the recommendation of the hearing officer, it's as supplemented by the general counsel. I, of course, don't know if that's going to be what the motion is, but if it is, that's what I recommend.
This is Member Brett. Can you hear me in Chicago?
Yes.
This is Member Brett. I move to accept the recommendations of the hearing officer as supplemented by the general counsel.
This is Member Turbin, I second that.
Amy, roll call.
Ms. Ballard-Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Turbin,
Yes.
Mr. Fred,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passes.
Thank you. All right. Just to add, as a closing to this and what has been said, that there has been numerous hours on everybody's part put into this, and I would like to commend our staff because they've done incredible work and hours, extra hours, and we thank you for that very much.
Absolutely.
Yes.
Thank you.
Thank you.
All right. Number 4, objection dismissed for Fiedler versus T. Brogdon. Marnie?
If I can make a quick comment, I just wanted to let council on the last name know that their order is not yet ready. It will be emailed to them this afternoon because we did not know how the board was going to rule. So now, moving on to Fiedler versus Terry and Broden, 24 SOEB GE 506. These nomination papers were dismissed at the July meeting for failing apparent conformity standards, and I ask that the board please dismiss this matter as moot.
All right.
Oh,
Do
I'm
we
sorry,
have,
Mr. Fogarty is here.
Oh, that's okay.
Mr. Fogarty is here on behalf of
The objector.
the objector.
And we agree. We agree. Thank you.
all right. John, so you're all right? Okay. Do we have discussion? Questions? Do I have a motion?
I make a motion to dismiss the objection as mute. Is that the correct motion? I want to make sure I make this right.
I think so. Do I have a second?
I second the
Member
motion to dismiss the objection petition as moot.
Thank you.
Roll call, Amy.
Ms. Ballard Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
All right. Is there any other business to come before the electoral board?
Thank you.
Then do we have comments from the general public?
Mr.
On the
Finkel was
electoral
reading
board.
Well, you know, I just wanted to ask if the comments could be directed to the electoral board rather than waiting for the state board.
Yes, yes.
That's
but
what
the
I'm asking.
public comments-
That's where we are right now, Mr. Finkel.
Thank you, Your Honor.
As long as there's no other business.
Nope, there's no other business. So this is the electoral board. Isn't that what he said?
Yes, I
Okay.
believe there are a number of individuals here who wish to make public comment. So yes.
And so I would ask if there's a number, I think there are a few here, and there are a number in Chicago. Would you like Mr. Finko to go first? We don't want you to duplicate. So, and we're going to do 2 minutes, I think, 2 minutes each. So Mr. Finko, would you like to begin? Or would you want to end? You want to wrap it up?
Sure, I'll comment.
He's coming. And Mr. Finko is stepping up. There was a little bit of a traffic jam.
All right. Thank you. Thank you, members of the board. I do want to thank the board and staff and everyone for reviewing this objector's petition very carefully. And just I would like to offer suggestions for future. And my comments are that an objection must be lodged against a candidate who is on the Illinois ballot. So that's the threshold inquiry. And this objection was lodged against candidates who are out of state and who are not going to be on the Illinois ballot under the election code, not looking at the vernacular. So under the election code, there's 2A-1.2, we have a checklist. So the objection has to be against one of those offices on the checklist. The second recommendation is that an apparent conformity be adopted so that if an objection does not meet that standard, that the objection be not accepted. And that's where we would have saved a ton of money and time, because this objection sought relief that was not possible under the election code as was recognized by the hearing officer at the last tail end of pages 79 and 80 of his report. So, you know, it's something that, and just not to let it go, the beating up of Robert F. Kennedy Jr. here for using an address in New York. He's a lifelong New Yorker. He's registered to vote. He resided there under the law, and that's where we look at from a legal point of view. In Chicago, Mayor Rahm Emanuel, before he was elected, resided in D.C. That did not make him a liar. That did not make him a liar when he submitted nomination papers in a statement of candidacy saying he lived on North Hermitage Street here in Chicago. So that's the clarification point. And obviously, we all know there's a lot of political posturing that was going on in this case. So please take that into consideration. He did not lie in the sense of perjury. But I do want to thank the board for its time. Thank you.
Thank you, Mr. Finko. Can we have someone from Springfield? Would you like to come up here, please, and state your name? And if it's a difficult name, would you spell it for our court report?
It's not difficult.
Okay,
So.
and speak up and speak in to the mic.
Good morning, members of the Illinois State Board of Elections. My name is Sean Phillips, resident of Springfield, Illinois, and citizen of the United States. Thank you for taking time to hear my comments. I'd like to extol the untiring efforts of the Board of Elections during this petitioning cycle. This is a hard job in face of high political tensions, and there's opportunity to collapse in upholding our state's law sincerely. However, what I've witnessed is you and your team at the Board of Elections embrace fairness, kindness, and steadfastness to uphold the democratic processes that make this an unyielding state of the union. At 30, this is my inaugural time I've collected signatures, donated time, given energy, or engaged with a campaign besides simply voting. It is not quite what I imagined. It's sloppy at times, divisive at others, and full of wonderful people. And the people are what amaze me. This passion that many of my fellow citizens have shown to connect with each other to support a candidate that we feel best represents our views for the country has been a tremendous experience. Having seen the physical delivery of more than double the required signatures submitted by Robert and Nicole's campaign was truly a sight. The paper petition assemblage was a privileged perception. That long papers trail revealed why Bobby's words and moral courage inspire his voters, that through strength of spirit, we can be reminded of what's important, to heal our nation's divides, to clean up environment, to speak the truth, and to stand for the best version of ourselves in this nation. Anything less is a disservice. These two candidates provide the spark to a flame that re-illuminates the possibilities of America. In this light, myself and thousands to tens of thousands of Illinois citizens are grateful for the favorable ruling today to have Bobby and Nicole appear on the federal general election in November. Thank you.
Thank you so very much.
Thank you.
I'll go to Chicago. Please state your name and move over a little bit. We can't see you.
I can call up first Mr. Little, Lytle. He was the first to submit a appearance form.
Thank you, Council. And I promise I will be brief because we have a lot of folks here. Delighted to see you guys.
You got 2 minutes.
I have 2 minutes and I'll spend less. This was too hard. This was too hard. We had to submit 75,000 signatures to have half knocked off for any number of reasons, yes or no, but we needed 25,000 signatures in order to go for president. Angel needed 9,500 signatures. Her Democratic opponent needed 300. 300. It's too hard. The election board does not make these rules, but I'll tell you what, the person who put you here, whoever that was, whether it was the governor or the president of the Senate or the minority leader, whatever it is, they darn well can change that. And we will be calling our representatives to say, change it and make it easy to get on the ballot. I would implore the election board to do the same with your sponsor. Call the governor, call the minority leader of the Senate and say, please, please make this fair. That's what we want. Now, we're delighted that Kennedy's on the ballot. Hooray. Guess who's not? Angel. Jill Stein, the Libertarian candidate. Several other candidates weren't here. Why? Because they didn't get an absurd number of signatures. We do not need to put that barrier in front of people. We should be free to vote. It's a piece of paper. Print another damn piece of paper and put more candidates on it and give us the choice, please. Thank you.
Thank you, Mr. Lytle. We have a speaker here in Springfield. Would you state your name, spell it for the court reporter, please?
Oh yeah, I'll need to spell this one. Hi, I'm Kirsten Bonanza, KIRSTEN BONANZA, resident of Springfield. I'm honored to be here. I want to echo what I've heard so far from Sean and others, who may not be here today, that thank you so much for the long hours everyone put in for showing up. It really, whether or not it was necessary is one thing, but it's appreciated. Everyone who's done that. And the cookies really are amazing. So those of you in Chicago are missing out. But what I want to come to is that fundamentally as a democracy, we're here to create the opportunity for people to choose to create their lives as better and to choose to create our communities as better. And choice includes having more people on the ballot, more ideas being shared. And really, I'd like to echo what Bob was saying, that the barrier of entry is a little bit too high. Not only that, but when you look at the signature sheet itself, it doesn't give the voter enough information about what's actually required. So I was watching as the signatures were being counted, as signature after signature got thrown away because a college kid didn't realize that their home address was the wrong one. Like so there's some information that could be added, but like this is a general public. When was the last time your signature was updated? Well, there was one person I remember seeing, it was like 1984. Well, my signature's changed since 1984. Has yours? Mm-hmm. So there's a lot of little things that I think would contribute to making this process more ease. And I urge everyone to call whoever you need to call, talk to whoever you need to talk to, so that we can bring more of a possibility of what we can create rather than fighting to keep people out, because it's just a waste of time. I've got more to create in my life and this community. So please join me, and thank you all for being here and everything you've done, truly.
Thank you, Ms. Bonanza. Chicago?
Great. If I could call Speaker Turka, if that person could please spell their name.
I'm gonna withdraw my.
Oh, okay.
Thank you.
Thank you. In that case, Speaker Bonanza. Okay, I'm sorry. Oh, I'm sorry. I thought you were up here. My apologies.
I'm here. I'm not going anywhere. I just.
She thought you were in Chicago.
No. Thank you.
Yeah.
All right. I think
We have all our speakers here, Marnie, so you call from up there.
Oh, yes, Speaker Crona.
Sally Crolla? Sally.
Yes, if you could spell your name, please.
Kroha.
I think a little louder to make sure that they can hear you down in
My name is
Springfield.
Sally Crolla, Kroha. I'm a volunteer for the Kennedy campaign, and this is the first time I've ever really dug into, I've ever worked for a campaign, ever donated a campaign, ever signed petitions. And as an American, it has been really eye-opening, and I just echo the things that have been said before about how incredibly challenging it is to get a candidate that you believe is very qualified on the ballot. And I just want to compliment the campaign workers, because they trained us again about what to do, what not to do, how to make sure somebody is registered to vote. So I just feel like, as an American, I have now a new eye open on the democratic process, which I think is broken in many ways. I love being an American, and I echo, like, let's make it better. Like, let's give more voices. I read, I'm not a lawyer, but I read that after Ross Perot, every state got to create their own laws about how candidates can get on a ballot, and it is very challenging and difficult that 65,000 petitions that need to be strung together. As a citizen, I don't get it, but I can see why it's a barrier to entry. So I thank you all for listening. I feel like democracy was upheld today, and just really appreciate the time.
Thank you. Marnie?
Okay, the next speaker I have listed, I apologize for the mispronunciation I'm about to do, Amanda Jocko. I'll withdraw. Okay. And next I have a Speaker Chamberlain. And ma'am, if you could please spell your name.
Yeah, sure. So my name is Dr. Laura Chamberlain. I'm with Casper. Where do you speak? Where do you look at? Anyways, I'm Dr. Laura Chamberlain, and I am a longtime election integrity activist since 2003 with
Can you spell your name for me, please?
Yes, Dr. Laura, L-O-R-A, Chamberlain, C-H-A-M-B-E-R-L-A-I-S. And so with, I've done work with Clean Count Cook County, Illinois Ballot Integrity Project. I've been on many petition drives for good government referendum, and it is too challenging. And I'm asking the board members, could we have a meeting where we get together, because I know that you're administrative, but you also have lobbying capabilities. And we are, I don't know if you've seen the latest polls, but some of the polls show that 51% of Americans now say that they're independents. They are not with either one of the established parties. So this whole process is going to get bigger and bigger and bigger. If you thought the Kennedy thing was big, strap in. So I'm asking you to please meet with us and let's go through this and try to streamline this overstuffed election code that has been designed by the established parties to boot, the third parties and the independents off the ballot. But that is not what that's not the direction that the American people are going. So, can we work with you? Can we sit and talk about this election code and all of the requirements and all of the minutia that is cubby-holing our democracy and leaving American voters starved for some kind of representation? Thank you.
Thank you, Ms. Dr. Chamberlain. I believe that's all, definitely from here in Springfield. Marnie, is that all from up there?
I have a speaker here. I'm unable to read the name, but they want to speak about candidate Stein.
Yes.
I'm sorry, ma'am, if you could state your name.
Yes, my name is Zoe Ma, and I'm a supporter of Jill Stein, and also I'm the chair of Cook County Green Party.
Could you spell your name, please?
Zoe, Z-O-E, Ma, M-A. And I want to tell you my story. America has preached to the rest of the world for 40 years that the rest of the world should adopt democracy in their country. 35 years ago, I rode on the train for 30 hours to go to Beijing, Tiananmen Square, to protest against the government. And some of us was asking for democracy. After that, I left my Asian parents. Later, I gave up my Chinese citizenship, so that's the only way I can become American citizen, so I can vote in this country. But what I learned in the past 30 years, I came to this country to learn if the democracy can help people out of poverty, because that's what we protested in 1989. But after 30 years, I was so disappointed with the American system, and especially the democracy. I almost gave up. I want to exile myself out of the United States because this system has made people poor. In the past 30 years, China has managed to get 800 million people out of extreme poverty. There's no homeless in China, but I see more and more Americans become homeless, living in poverty. Only Jill Stein gave me a little hope when she was arrested supporting students protest against Gaza genocide. Because my past was a student activist, so I signed up to get her on the ballot. I worked tirelessly in Chicago, in New York. I flew to New York to help her. But what I found is the system is really set up against the small, marginalized people for their representation. So what's the difference between America and the China? I think if you want the rest of the world try to be a democratic system, show the rest of the world democracy works in America, but totally it's a fail. You throw the ballots out just because somebody cannot read, just clearly on the way to work. We so hard, and then there are also the new immigrants. They are coming from another country. English is not their first language, so they write their name. You can't even fit in the line, the little box. So you throw their signature out. So I'm just saying, and now your system to allow the establishment party have only a few hundred signatures, and the independent to have 25,000. You are.
Thank you for your comments. Your 2 minutes are up. We thank you.
Well, I'm just saying here, I cannot breathe because I cannot breathe. It is a fake American democracy.
All right. Is there any other business?
I have another appearance request, this one from a candidate in a prior case, Angel Oakley.
All right. 2 minutes, Ms. Oakley.
Oakley, if you could spell your name.
Sure, it's Angel, A-N-G-E-L, Oakley, O-A-K-L-E-Y. I have quite a bit to say, but I will try to keep it to 2 minutes. And thank you to those down in Springfield who did go through the signatures. I went through this in the last election with candidates, and everyone was wonderful, and it was a great experience. I will say for this experience with Kennedy, I am an elector for Kennedy as well, and I was very disappointed. It was not the same, and I think it was because the number was so large that we had to go through this. The stress level was high, and so everybody's nerves were a little shot because it was so contentious. And I understand the environment being difficult, but then we have to ask ourselves, and why are we asking for so many signatures? Because when we ask for that many signatures, then we have to review that many signatures. And the fact that he got so many, getting 3 times as many as needed, because there was worry that exactly this was going to happen. Now, in my particular case, I didn't have the millions of dollars to put into it, and so we had a grassroots campaign, and I had 200 people that had petitions in hand to get signatures, but I had a whole lot of people that were just unable to go and ask. So we had 40 people turn in signatures that they had collected. So we had 40 circulators, which is way more than either one of the candidates running in the Democrat or Republican seat. So I had more support in that regard, but I also couldn't enlist because of this party thing where I had Democrats and I had Republicans that wanted to help me, but they couldn't because they were Democrats or Republicans and they were afraid of what treatment they were going to get from the party, or they were afraid of then their petitions being tossed out for dual circulation. So there was a lot of support that I could have gotten that I couldn't because our hands were tied. I found the regulations just terrible overall, and definitely not in favor of democracy and more voices. People wanted me to be on the ballot, and I had 8,400 people sign. We had tons of people that we rejected because we were trying to follow all the rules, dot all the I's, cross all the T's. We told them no if they weren't registered to vote. If they said, oh, I haven't registered yet, I just moved. And go look at how many properties have turned over, a lot. And a lot of those people have not registered, and so we rejected those. We rejected the crazy gerrymandering. And so if you have any sway over helping make modifications, I think we need to go back to the 5,000 is way more than is needed to accommodate the state's burden. And the state's burden is really just to say we don't want overcrowding of the ballot. Look at the history. There's never overcrowding, even when you only require 1,000 signatures.
Thank you. Arnie?
Has not seen any more forms. Did I miss anyone who filed a form?
No.
I did not.
I see no other speakers down here for general comments. So, is there any further business to come before the State Board of Electors? If not, Amy, roll call, or do I need a motion to
adjourn?
Or
Recess.
right?
Recess until September 17th or until the call of the chair.
Second?
Second.
Turbin, second. Amy, roll call.
Ms. Ballarcroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes. Let me take a break.
All right. Now we will call back to order, State Board of Elections. Do I need a roll call that we're back in?
Yeah.
Roll call, please.
Ms. Ballarcroft?
Here, present.
Ms. Craig?
Present.
Ms. Genovese? Lazy?
Yes.
Yes.
Oh,
She's absent.
okay.
Ms. McCrory?
Yes.
Absent. Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Yes.
Oh, sorry, Cassandra. I'm just gonna say, let's take 5 minutes, and I know probably people would like more, but we've got people waiting for the real our other board. So we'll take 5 minutes to get the office of Chicago clear to people.
I don't know if you guys saw, but, this morning, Jack and Rick.
All right, let's go back. Oh, I can like across.
You could have listed names of those people that were speaking.
They're back.
Names, people that didn't end up getting up, but you said their names, so I need to.
Oh, okay. Here.
Okay. He's asking a question. Okay. All right, are we ready? So we are sitting now as the State Board of Elections, and we have a report of the General Counsel campaign disclosure, motion to reconsider.
And, Madam Vice Chair, just to let you know, the executive director is not back, but she doesn't really need to be here for this part, I'm hoping she'll forgive us and we'll proceed. All right, so first I have a motion for reconsideration up. SBE versus Friends for Eva Dina Delgado, 23 AF 37. Is Ms. Delgado or anyone here on behalf of Ms. Delgado? Oh, excellent. Okay, ma'am, I will read my recommendation and then you'll have an opportunity to address the board. So the committee is moving to reconsider fines totaling $11,850 for late filing of 9 Schedule A1 reports, first disclosed as received on September 11th, 2023. The final order assessing the fines was dated June 21st, 2024, and this motion was received on July 10th, 2024, within the 21-day window applicable to motions for reconsideration under Rule 125.440. Committee says it mistakenly reported the date of receipt of the contributions as 1 month before the October 11th, 2024 fundraiser at which the funds were received due to a data entry typo, and they also provided a flyer evidencing the date of the fundraiser. After investigation, the committee said it discovered the relevant date of deposit was October 16th, rendering the October 16th A1 filing timely. The committee has already amended its quarterly report to reflect the correct date. The committee says it did not appeal the initial notice of violation because although it was dated April 15th of this year, it was not received until mid-May, and it took the committee time to investigate whether a mistake had been made after receiving the notice. And as the delay in the mail is a circumstance beyond the committee's control, and the underlying appeal is meritorious, I recommend granting the motion to reconsider and reversing the $11,850 in fines.
Do we have discussion? Oh, I'm sorry.
No, no worries. Heather Wire bought on behalf of the committee. We obviously appreciate.
Oh, your name.
Oh, sorry, WIERVAUGHT. On behalf of the committee, we obviously appreciate the board's time and consideration on the matter.
All right. Do I have a motion?
I have a motion to grant the motion and reverse the relevant fines.
Member Brett, second.
Sorry, that was Member Craig, made the motion. Sorry.
Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
All right. Now, Marnie, we have a Michael Navarrete that is going to speak on 3A4 here in Springfield or Chicago? Chicago?
Yes, he's
And-
in Chicago.
Can we go to that and then go back to the other 4?
Absolutely. I'll
All
call
right.
that case as SBE versus Friends of Michael V. Navarrete, so correct my pronunciation, I hope, 23 SQ 134. I will read my recommendation and then sir, you'll have an opportunity to address the board. The committee is offering $385, which is 26.10% or 26.1% to settle $1,475 in fines for late filing of the March 2022, September 2022, and September 2023 quarterly reports. The offer is compliant in terms of balance and receipt ratios, and although it is below the 50% standard, the committee is considered low dollar. This offer represents 50.35% of the committee's current fund balance of $764.60. Therefore, I recommend accepting the offer.
Mr. Navarrete?
Oh, thank you. I did have a statement prepared, but in respect for everyone's time, I would just say I express my gratitude and consideration for the settlement offer and appreciate the fairness and transparency of the process. So thank you so much.
We thank you for keeping your remarks shorter. Do we have a motion, please?
I move to, this is Member Ballard Croft, I move to accept the settlement offer for the amount of $385.
Second.
Second by whom?
Roll call, please.
Oh, I'm sorry, we couldn't hear who the second was.
Okay, with Mr. Turvin, seconded it.
Thank you.
Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Turvin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
Thank you, Mr. Navarrete. All right, we'll continue with settlement offers 3A2, 3, and 5. Attorney?
Can I just confirm that no one is here either in Springfield or Chicago on a settlement offer?
Is there anyone else here in regard to these? No, they're not. In Springfield.
Okay, well, in that case, I think we can do a group motion on agenda items 3A2 and 3A3 to deny the settlement offer.
All right.
So moved.
Second.
Amy, roll call?
Ms. Ballard Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Turvin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
All right, Marnie, on 3A5.
On 3A5, my recommendation is to accept the settlement offer of $1,313 as it comports with settlement guidelines.
Any discussion? No. Do I have a motion, please?
Member Craig, so moved.
Member Brett, second.
Amy, roll call?
Ms. Ballard Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Turvin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
Okay, now, Marnie, on the assessments, we have to make a motion to accept these assessments?
Yes, please.
All right, hang on a second. Okay, where am I? Do I need a motion to accept the assessments, right, Barney?
Yes, please, on pages 32 to 34 of your packet.
All right, do I have such a motion to accept the assessments?
Member Turvin, accept motion.
Member Brett seconds the motion.
Amy, roll call, please.
Ms. Ballard Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Turvin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Present.
Motion passes.
All right, then the, also under that line item is we have ballot forfeiture list and the, payment of civil assessments. They're both informational. So we don't need motions on that. Am I correct, Marnie?
That's correct.
All right. Then I need a motion to go into closed preliminary hearing, or complaints following a closed preliminary hearing. We need to go into private session, don't we?
Session.
1 second. Jennifer, I understand, does it need to be at 1? Is that a particular time you need a break?
Yeah,
Can you do-
no later than 1:15, but yeah, so we can time it with the arguments, but 1 to 1:15.
Gotcha.
The
So
first case should be here.
yeah, because we
Oh,
need,
we need a motion.
we need to, a motion to go into closed session.
So moved.
Second, Member Price.
Roll call, please.
Ms. Bellercroft,
Here, yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Verret,
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
Yes.
Motion passes.
All right.